Hi, everybody. It's Meredith Nagel coming to you live. You might have heard me say that already. We're trying to get the technical details down pat because this is only our second of what is going to be a weekly presentation called Ask an Attorney Live. Last week, we had attorney Heather Ward talking about the Corporate Transparency Act and then taking general questions about not only that, but any other subject. Today, oh, my bangs, guys. Today, I am going to be talking about powers of attorney. And we'll also then be taking questions not only about that subject, but also about anything that you might, have coming to mind as you're sit here listening to me talk. And again, it doesn't have to be about the power of attorney. I'm glad to answer any question that I can today on any legal subjects. And that covers a lot of subjects. I've been doing this a long time. So, without further ado, let's talk about powers of attorney in Florida. So, from time to time, you're going to see me looking at my screen over here. I'm looking at notes because I want to make sure that I cover all the topics that I want to cover. So, first of all, I need to say that if I could carry around a sandwich board or some kind of advertisement that everybody could see to give them one tip that would really make a difference in their life, it would be to have an appropriate power of attorney. A power of attorney is a legal document that allows you to say who can make decisions on your behalf. You are what we call the principal under the power of attorney. The agent is the person that you choose. And in this power of attorney document, you, the principal, say what authority and what acts that the agent can take on your behalf. So sometimes powers of attorney are very limited. It is like for example, you're buying a piece of property. You can't be in town to sign documents. So you sign a limited power of attorney, giving someone the authority to only sign closing documents, as an example. You can give someone a power of attorney to deal only with your banking. You can give a power of attorney to deal only with the IRS on one specific issue. The great thing about a power of attorney is it can be tailored precisely to your situation. But when I say everyone should have one, what I mean is a broad general power of attorney. And when I say everyone should have one, it's based on my experience doing this now almost 27 years. The number of times that people are not able to take care of their business because they're not in town or they're sick or in their hospital or something's happening in their life and there's nobody to take care of business on their behalf. And the sad thing, especially if we're talking about elderly, incapacitated people who don't get better, if they don't have a power of attorney giving a child or friend or someone the ability to take care of them and they start losing it, then you have to go the guardianship route, which is extremely time consuming. It's extremely expensive. And so that's for that reason. That's why I would carry my sign around saying, make sure you have a power of attorney so somebody can represent you if need be, because when these situations arise, it's frequently an emergency. And if we don't have that power of attorney, we only have two options: do nothing or get a guardianship. Neither one of those are good options. The power of attorney is the best option, and they're so easy to get. Now, um, I will say this. I have lots of questions like, do I have to go to a lawyer to get a power of attorney? Can I just get one from LegalZoom? Can I just get one from fill in the blank? So I have to tell you that, of course, I think that a lawyer brings value to the process because I'm a lawyer. But I don't just think that because I'm a lawyer. I think that because, unfortunately, while it may seem simple to do something based on what you see on the internet, if you haven't figured it out already, most of the internet has turned into advertisement. For example, if I Google a subject, like let's say I want to look up a rule of civil procedure and I Google that, the first two or three pages will be lawyers advertising their services in that practice area. And very frequently the things they're saying in those articles are actually not true. I think sometimes those articles are not written by attorneys, or maybe they're written by bots or marketing people. But for whatever reason, a lot of the time, even information that looks like it comes from an attorney online might not be accurate. Even worse is when you just try to figure it out on your own and fill out the document. We frequently see them not done correctly. For the power of attorney to be valid in Florida, you need two witnesses and a notary. And it must be signed in front of those witnesses, and it must be acknowledged before the notary. There is no way around that. You have to have the witnesses and the notary. So we often see failure there. There won't be enough witnesses. Another place that we see is that the power of attorney doesn't actually do what we need it to do. So a lot of the online forms um, don't properly, for example, describe the right of your agent to sign and sell your homestead. So if somebody shows up and is trying to sell property, for example, under a power of attorney that's not appropriate, the power of attorney is worthless and we have to go to court anyway. Also, under the Florida statutes, you have the ability to give your agent, the person who's working on what we call superpowers, and that is really to take care of you in every arena. And you'll need to talk with a lawyer about when that's a good idea, when that's not a bad idea, what the good things, the bad things that could result. So it's really not, even though it seems like a simple document, it's really not. Not if you're going to do it correctly, and not if you're going to get what you're actually looking for, which is a document that will be acknowledged by the appropriate people and will do for you what you want it to do. So that's the first thing. If you're going to use a power of attorney, number one, know what you're using it for. Is it limited, or is it full? Or do you really want them to be able to do everything? So what's it for? Second thing is it has to be executed correctly, right? Two witnesses and a notary. The third thing that I need to let you know, it's like a very common misconception, is that there are no, when you die, your power of attorney is of no effect. That's one of the most important things that I wish people understood. A lot of people think, I have a power of attorney for my mom. Mom dies. I now have the authority to go get mom's checking account, sell mom's property because I have her power of attorney. In fact, when the principal dies, the person who gives the power of attorney dies, the power of attorney dies as well. It will not be effective after the principal dies, period. For that reason, people are frequently not getting estate planning done. They're not taking other actions because they think that they'll be able to after the person passes away, but they will not. So you need to know they're immediately ineffective on death. The other piece you need to know is that they are immediately effective when signed. And what I mean when I say that is as soon as that document is properly signed and it's in the hands of your agent, they have the ability to do anything, including some scary things like walk up to your bank and clean out your account. The way that the law works is if the power of attorney is properly executed, those things that I told you, if the bank relies on it and it turns out that your agent has just stolen your money, guess who's not responsible? The bank, right? So these are very powerful documents that are immediately effective when they're signed. And for that reason, you frequently have a lawyer, again, another reason not to do it yourself, a lawyer, we will do what's called escrow the power of attorney. And what that means, that's our fancy way of saying is you sign it and then we'll hold it in our files and we won't give it to the agent until you say, the principal, that we can, or a doctor tells us that you are incapacitated, or we have good reason to believe that you cannot be located. So we lay out certain parameters that say to me, and when we draft these, when you sign your power of attorney, that's when you also sign that letter to me. And that letter says, attached is my power of attorney, Meredith, don't give it out under these circumstances. And again, that's to protect you because to reiterate, if somebody has a power of attorney and the power of attorney itself is valid and someone relies upon that power of attorney, and that person is ripping you off, those people are not going to be responsible. You're not going to get your money back from the bank. You're not going to get your money back from the IRS. You're out of luck. So it's a very powerful and strong document that you need to care for. Treat it as such, because there's also a common misconception that these documents are not in effect until you need them. In other words, I can sign a power of attorney now and it won't go into effect until I'm incapacitated. That's not how the law works anymore. Most powers of attorney are what we call durable, which means as soon as they are signed, the document itself says it retains its power during incapacity if you become incapacitated, but it does not require incapacity or unavailability or any of those things. That's why we say it's such a powerful document, because as soon as it's signed, your agent can take it and go do what they want to do and doesn't have to prove to the bank or whomever they're dealing with that you can't handle your affairs for yourself. So that's another really important reason to get it done through a lawyer. The other thing that I wanted to highlight before, I take any questions that you might have is that when you're evaluating a power of attorney, it's super important that you actually understand the powers that are being given. And again, that's where consulting with a lawyer can help you. Because if you're just reading a form and it says, for example, that your agent has the right to draft a trust on your behalf, for example, that's probably not going to be good enough language to satisfy the federal government if we ever needed to do, for example, a Medicaid trust. In other words, what I'm trying to say is because these documents are so powerful, the language is very specific and needs to cover the things that it needs to cover. I think I don't have it in front of me, but it seems like our power of attorney that I consider to be the gold standard is like 9 pages long. And you're like, oh, yeah, that's really, really long. It is really long because it covers everything and it's a rock solid document. Someone asked me, is it advisable to designate an alternate? And the answer is absolutely. That's going to be something the lawyer's going to talk with you about, because if you just designate one person, and I'll use my life as an example, right now, my power of attorney, the person who has control over me, in my document, or control over my affairs, in my document, it says first my husband, then it says if he is unwilling or unable, then my oldest son, if he is unwilling or unable, then my second oldest son. So if, for example, a power of attorney action needs to happen and my husband and I are out of town together, then my son, my older son could go and exercise those powers instead of. So it's really not only a good idea, Evelyn, but it is really kind of necessary because you don't want to go to all this effort to create this document, and then the time you need it, your agent is not available, or maybe was even injured with you or with you out of town or whatever in the scenario I just gave you. Another question we have is, I have the power of attorney. Can I make changes to it later? And the answer is yes. However, what lawyers always say, yes, but you can, however, you need to officially revoke it. Once that power of attorney is out there, it's out there. When you do a new power of attorney, it automatically revokes the old power of attorney, but you have to tell the people that you gave the old power of attorney to that there is a new one. So, to give you an example, let's suppose that I make my husband my power of attorney, and I give that to my bank, Main Street Bank. And then let us suppose that my husband and I get a divorce, and a year later, my husband takes my power of attorney down there, wipes out my account. He's still going to be able to do that. I would, in my scenario, have been smart enough to do a new power of attorney if I got divorced, but I might not be smart enough to let every institution that I gave it to previously know. So yes, you can change your power of attorney later, but again, this goes back to how important these documents are. Once you change it, you're going to need to make sure that everybody that might have had a copy of the old one gets a copy of the new one instead. And again, that's a great reason to have your lawyer hold this document in escrow In other words, remember I gave the example of the cover letter? Let the lawyer hold it and only give it out when it's needed. So somebody asked, he's got two properties, 50-50 with my old business partner. How can I get the property changed to solo ownership? He is not cooperative. Okay, so when we do these, we have to be very careful. Tuscan Hills, I don't know any of the facts of your case, so I cannot give any specific advice to you. So I need to let you know that as a member of the Florida Bar. However, I can speak generally about what happens when you own property with someone else and you don't want to. Before I do that, though, I'm going to just do one more thing to help you on the power of attorney, so we can uh, clean that whole thing up. You heard me at the beginning talk about if I had a poster that I could carry around that said one thing as a lawyer to do, it would be have a power of attorney. And I've told you all the reasons about how they can be helpful and all of that. But I want to circle this around to the final reason. This is what I need you to be telling your friends. I need you to be sharing this video. It is critical that our older family members and friends have powers of attorney. I cannot tell you guys the number of guardianship cases that my firm does, and we do a lot of them. The number of cases that we do where if there had just been a power of attorney, if mom had just signed that power of attorney in favor of daughter before she finally checked out, the guardianship would not be required. And this is a big deal, guys. The average guardianship is going to cost you around $10,000, and that's just to get it off and going. Then you have to make reports to the court every year on how you spend their money, and you have to make reports on how they're doing. I mean, it's very, very burdensome. It's to be avoided at every possible cost. And nobody wants to be involved in the legal system if they don't have to, including good lawyers. I'd much rather do a power of attorney for you than have to do a guardianship for mom or dad. So please, and part of the problem, guys, including with my own parents, a lot of time the parents don't want to give the powers of attorney over because then, they want to preserve their dignity and they don't like their kids being in charge of things. Have them call me because I know what they would like even less is a guardianship. Okay, so if anybody has any more questions about those, I will answer them. But first, I will answer Tuscan Hills question. So here's a really cool thing, Tuscan Hills. Just like in Florida, you cannot be forced to marry someone, stay married to someone. So if I wanted to get a divorce, I don't have to prove my husband did anything wrong. He's not a good husband. I just say, I don't want to be married. And the law says, okay, here's a divorce and here's how the law goes. Same thing with real property. Florida cannot force you to maintain ownership with someone that you don't want to be in business partnership with. If they will not agree, we have an action in Florida called partition. It is a no-fault action in the same way that a divorce is a no-fault action in Florida. In other words, I don't have to prove that my co-owner's a bad guy or he did something wrong. Nothing. It's just I simply don't want to be on this property with him anymore, and he won't agree to sell it. If you do that, the court will absolutely grant your requested relief, will order that the property has to be sold and the proceeds divided. Of course, you never want to go that direction if you don't have to, because all of that is going to require attorney's fees. Sometimes the court appoints a receiver who charges their own 6% on top of the realtor commission. So it can become a very expensive process. But yes, it's always available in your back pocket. And many times the threat of it alone, hire a lawyer to write a letter, not really threatening, just explaining the law, saying, hey, my guy wants out. Don't make us go to court and spend all this money. Sometimes those letters alone, Tuscan Hills, can make a difference. Camille had a comment. Her mother died. No probate does. Let me see. They are saying now to collect settlement anywhere around it. No creditors. Okay, mom died. Before she died, she was involved in a car accident. Almost 6 months later, the insurance made the highest offer. No probate done. Okay. No, Camille. Unfortunately, you have to open a probate to accept money that comes into your mom's estate, even though that's the only thing. We have no way. This happens a lot, Camille. We'll find a small bank account that we didn't know about, or a life insurance policy that didn't have a beneficiary, or a settlement agreement. You can't process those, and you can't do any of that without opening a probate because they're going to insist, rightly, on paying the estate. Now, it could be if enough time has elapsed, we maybe can massage that if we're past the creditor period, but not generally. Generally, the insurer will require that, in fact, the probate be open so that the insurer knows that they are protected by making the check to the estate. They don't have to decide who it's supposed to go to. I will tell you that we have not all probates cost the same. So a full administration of a probate would be one cost. If you've only got one asset, depending on the value of the asset, that will adjust your price for the probate downwards. So, in your case, your problem, I know what your problem is. You've got $2,500 and you're thinking to yourself, how much money am I going to spend to get this $2,500? Give us a call afterwards, and we will talk to you about some strategies that maybe could apply in your specific situation that I don't want to talk about in a general way. I will just say, generally speaking, any assets that are payable as a result of happening while someone was alive has to be paid into an estate, and then an estate has to be opened for that purpose. There is no time frame for a probate. In other words, you can open a probate anytime you want to. Creditors have 2 years after the person dies to bring a claim, even if you don't open a probate. In other words, creditors are supposed to be looking through the death notices in the newspaper and be keeping track of who's alive and who's not. So in any event, 2 years is how long creditors have before they can bring a claim. Can a trustee or successor trustee use a POA? Thank you for actually asking such an excellent question. So many times, people think that their power of attorney is going to work because they're like, okay, Nagel says to get one. I've got my witnesses, I've got my notary. Unfortunately, there's some times when we cannot use a power of attorney, even if we want to. One of those is generally in the trust context. So let's use my life again as an example. My husband and I have a revocable trust, and it says that we are the trustees. And it says that if one of us is not available, then one of our children is supposed to step into that person's place. So if I'm sick and I can't sign documents, then my successor trustee, who in my situation would be one of my children, is supposed to step in. What I cannot do in that situation is give a power of attorney to sign on behalf of the trust. Generally speaking, it has to be a successor trustee. And if you stop and think about it, that makes kind of sense because when people set the trust up, they said, if we can't handle our affairs, this is our successor, which is the same thing that basically the power of attorney says. So the law says that generally a power of attorney cannot act on behalf of a trustee as regards a trust. Similarly, generally, someone having a power of attorney cannot act as an officer for a corporation. So I am president of my company. Generally, my husband, Leon, cannot use his power of attorney for me to make decisions on behalf of the corporation. It's kind of a similar thing, right? Corporations are supposed to be governed by their officers and all of that. We have a different way of doing it through what's called a corporate authorization, which is beyond the scope of this. But the bottom line is the two main areas where you cannot use your power of attorney are on behalf of a corporation and on behalf of a trust. Excellent question, because I actually meant to cover that. So thank you for bringing that up. Okay, so I have been talking a long time. You guys have been excellent to hang in there. Before I let everybody go, I want to make sure that I have answered all questions and that there's nothing else. Remember, it doesn't have to be, well, you got me. It doesn't have to be about power of attorney. It can be on any subject that might be niggling your brain. Anybody? Going one, going twice. Gone. Oh, thank you for that compliment, Brenda. In closing, I will say this. I'm getting old. I'll be 55 in January. And I'm finding a lot more value in my life than I've ever found in just helping people. So when I tell you that we are here to help you, yes, are we making money? For sure. It's not a legal aid clinic. But the way that we do, and if you ask our clients, you ask people that work with our title company, you ask people who work with our law firm, they're going to tell you we're really just trying to help you, help the legal system, help the title world. And we'd like to have an opportunity to help you when you need us. So if you have a legal matter, the Legacy Legal Team is here to help you. 352-394-7408. And if you have a title matter, please send it to Concierge Title. Give us a try. Once you try us, you'll never go back. They have their own number, but I'm going to give the office number that I know by heart actually works too. So it's 352-394-7408. It is so wonderful to have seen you guys on this live. Thank you for those of you who have jumped in and said hello. Good to see you. Had great to see you, Latanya. Good to see you, Mike. Great to see you, Mike. But I haven't seen Latanya in a long time. So, anyway, love you guys. Thanks for being here, and go kill it today.